systemic appraisals and reform. And so I'd like to give a big welcome to our in-person audience and to the virtual audience. I'd also like to thank the organizers of the conference and the host universities. Where we are today has got to be one of the most beautiful universities in the world. It's certainly the vistas from our balcony here are unbelievable. It's a pleasure to be here in Bogota, and it's also a pleasure to see so many faces that I haven't seen in a long time, due to the intervention of COVID. So welcome everyone. Now, my name is Greg Taraposky. I am the moderator of this panel. I'm a trade and investment lawyer located in Ottawa, Canada. I do international trade disputes and investor-state arbitrations. I'm also the editor of Trade Law Guide, one of the sponsors of this conference. The subject we will be addressing today covers a diverse range of perspectives and issues. And as you all know, these issues are becoming more and more complicated as the international community addresses challenges that include climate change, environmental sustainability, shifting approaches to international supply chains, the proliferation of investment incentives. These past two issues we've heard a lot about earlier today. And then of course, investment review and approval. Today, we will be discussing these issues from four different perspectives. First, we will be hearing from Jonathan Bonilla. And Jonathan is an associate professor at the University of New South Wales in Sydney. His primary area of research interest is international economic governance, with a particular interest in investment treaties. He's got a really good foundational perspective that will help our discussion. Second, we will have Mala Sharma. She is the lecturer and course director of the LLM Legal Practice Program at London South Bank University. Her primary area of research interest is international dispute resolution, particularly commercial and investor-state arbitrations. As you can see from above, she will be participating virtually. The third presenter is Gustavo Guarin, who most of you already know. He's a PhD candidate at the Europa Institute, Saarland, Germany, and a trade counselor at the Colombian mission to the WTO in Geneva. Finally, we have Washa Lai. She is an assistant professor at Peking University. She applies interdisciplinary methods of social science and international law to the study of investor-state dispute settlement and global economic governance. And as you can see, she is also participating virtually. It is past 3 a.m. her time. So thank you very much, Washa, for being here with us. The way I'm going to structure this panel is each speaker will provide a short 5-minute presentation on their perspective on these issues. Following their presentations, I will be asking a series of questions to each of them to facilitate discussion. And then finally, the last 15 minutes are reserved for you to ask questions of the panel. Given the limited time we have available, as in the case of the other panels, I will be enforcing the time limits. So please, my apologies in advance if I have to cut off any discussion. So I'm going to start with Jonathan. And Jonathan will be presenting a paper on the development and diffusion of national investment laws. His paper seeks to identify and explain shifts in national investment laws over time. And what will become very clear from his presentation is when we think of investment law in the investor-state context or investment treaty context, it's very narrow. In fact, the subject matter is very broad, and a lot of the issues we've heard about in earlier panels are the cutting point, or the measures that will be addressing those issues are dealt with at the level that Jonathan will be speaking. This level needs to be recognized in international investment law At this point, it's not, only some elements are. And Jonathan will give us some perspective on this issue, this foundational issue on what is investment law. So over to you, Jonathan.
Thanks so much, Greg, and especially for all your work in pulling this panel together with the hybrid format. It's great we were able to get the speakers online involved, and thanks also to the organisers for what's been a wonderful conference so far. As Greg said, this is a paper on national investment laws broadly. It's a comparative historical study, and it's part of a wider research project that Taylor St. John, who is the co-author of the paper, and I are working on. The first part of the research project, if you're interested, was just published on Monday. It's a 25,000 word report to the International Institute for Sustainable Development that seeks to frame the field, and this paper is a kind of extension or building on some of that. And in the very short time I have now, I'm going to outline 4 claims that I'm going to try and convince you of in the presentation and the paper. So if you take anything from what I say today, hopefully you'll find this interesting, you'll want to follow up, reach out. It's these 4 claims. So I'm going to try and convince you, firstly, that national investment laws are interesting and important. So they're a subject of study that we should take seriously. We understood in this room as people who are interested in international economic governance and international investment law. Second, I'm going to try and convince you that although these national investment laws are interesting and important, it's a really serious mistake to approach them or to think about them just in terms of an investment treaty analogy. So it would be a really serious mistake to think about national investment laws just as a kind of domestic counterpart to an investment treaty. And in the question and answer, I hope I'll get the chance to elaborate on some of the reasons why I think that would be a mistake. But basically, it's because of the diversity in national investment laws, which brings me to the third claim I'm going to make, or the third thing I'll try to convince you of, which is that once we walk away from the idea that national investment laws are somehow equivalent to investment treaties, and we see them on their own terms, the field is almost overwhelmingly complex and diverse. That's even if we just look at the differences between national investment laws in existence now. And it gets even more complex when you try and open up the historical questions which are part of our study. So how to handle and make sense of the diversity. So the third claim I want to make is that it's helpful to think and recognize the diverse functions that investment laws perform. So this is a common move in comparative scholarship, comparative legal scholarship, to think about things in functional terms. And one of the key moves in the paper is to identify 7 different functions that national investment laws perform. Some of them only perform one, some of them perform several, but this sort of functional thinking gives us some traction on the questions that we're trying to answer, which are about identifying patterns and differences over time, trying to understand why those changes emerge, and then moving on to more normative or policy questions related to design and reform. And then the fourth claim then flows out of that. And so it's just that there are real payoffs. So in this paper particularly, and this is the real subject of the paper, is that there's a payoff to the functional approach. And one of the ways we illustrate that payoff in the paper is picking one function, which is the regulation of admission and approval of new foreign investment. That's one function that some investment laws, many investment laws perform. And in the paper, we try to show how a functional thinking can help us identify and explain shifts in the way that investment laws regulate admission over time, and in particular, help us understand the emergence of different modes of governance of admission that relate to what's broadly called investment screening. So the historical development of different modes of investment screening, that's at the core of the paper. Okay, so investment laws are interesting and important. That's the first claim I want to convince you of. The second claim I want to convince you of is that it's a mistake to think about them just as equivalent national instruments to investment treaties. The third claim is that it's helpful to understand the field through a functional approach. And the fourth claim is an illustration of the payoffs of this functional approach, which is a deeper exploration of the emergence of investment screening through national investment laws over time. So I'll stop there.
Right on, 5 minutes. Thanks a lot, Jonathan. That was great. You know, one of the helpful points that Jonathan makes are looking at these trends. Keep in mind, a lot of the bits out there are quite dated, and they've been slowly evolving over time, more so in the recent decade. But keeping in mind those trends and the fact that these local investment measures are the ones that really establish the measures that are in some ways circumscribed by these bits. They have changed. Have the bits changed to take this into account? That's something for you to think about in the future. So on to our next speaker. Mala will be presenting a perspective on reforms to ISDS that focus largely on procedure, but also covers some substantive matters. Her underlying perspective is the reconciliation of international investment law with other areas of international law. And again, you know, as Werner would know, you know, even in the WTO, which is a very sophisticated set of treaties, there's a lot of purposeful ambiguity in those provisions. BITS, it's much greater, very simplistic provisions dealing with very complex issues. Looking at other areas of international law is a very important part when you're applying the rules of interpretation under the Vienna Convention. And so over to Mala. You have your 5 minutes starting now, Mala.
Thank you, Greg, and thanks for the introduction and the warm welcome as well. So like Jonathan, I have 3 things to say. So my contention is this. We have the reforms process ongoing at the UNCITRAL, and the ICSID reforms process concluded last year in July. But in this paper, I try and explore that the reforms processes only address legitimacy crisis, and particularly the normative aspects of legitimacy, such as transparency, accountability, consistency of decision, and participation of third parties. And I argue that unless we make 3 fundamental recalibrations within the system, it is likely that this legitimacy crisis of investor-state arbitration will lead to polycrisis of investor-state arbitration. So what are these 3 recalibrations? Well, firstly, I say that reforms processes needs to address this. It needs to allow states to undertake measures to deal with emerging challenges effectively and flexibly without having to pay exorbitant compensation to foreign investors. Now, as we all probably know, that the standards of compensation that we see within bilateral investment treaties and investment agreements, they have their basis in expropriation. And for those aspects which are for those other breaches which are not expropriation or which are, you know, unlawful expropriation, tribunals usually fall back on customary international law, and particularly the principle in Horshoff factory case, that the principle of full reparation. And whilst the standard is that, as found in customary international law, we see that most tribunals make use of discounted cash flow forward-looking methods to calculate the amount of compensation. And we see certain new treaties providing for, you know, more factors to be considered while calculating this compensation, but those are just in the treaties. We are not sure if tribunals will take it exactly how probably the treaty drafters intended. So, and specifically, the reforms process we have within the UNCITRAL, for example, we have the code of conduct for arbitrators, but that does not really talk about arbitrators taking into account systemic impact of the awards. And I think that is one aspect that the reforms process sort of missed. The second argument I make is that investor-state arbitration needs to be reconceptualized as a system that recognizes imposition of investor duties and not just something that gives them rights and remedies. So we already see a disconnect between investors' rights and obligation. And again, new treaties are kind of trying to fill the gap. But if we look at the practice of arbitration tribunals, we see that while states do bring counterclaims, they claim set-offs, in most cases, they are not really able to get anything monetary out of the investors. But even if, for example, you are able to get some pecuniary compensation, I'm not sure how you are really going to enforce this. Whilst again, for pecuniary damages, it might just be easy, but particularly for restitution and say satisfaction, I am not sure how you are going, particularly within the ICSID framework, because of Article 54. I'm not entirely sure how are you going to enforce non-pecuniary remedies as against the investor. That is not to say that tribunals don't award it, they do, but their enforcement is still a bit tricky. And also we need to think about how do you deliver justice to affected third parties within the investor-state arbitration system. And my last contention or argument is that investor-state arbitration system fails to reconcile international investment law with that of other areas of international law, such as rights of indigenous communities, human rights, environment, and climate change. And I think there are a few barriers, not institutional, but just the way the whole system is kind of created and conceptualized. We see investor-state arbitration as an exclusive, freestanding mechanism where, generalist concerns such as climate change or human rights cannot be adequately determined. And we see it as a consensual process where disputing parties retain a lot of control over the process, thereby, for example, sometimes even stopping third parties from making representations. And in some cases, arbitrators are themselves trained in commercial law, and therefore they might not be open to receiving these human rights related arguments, for example. So because of these barriers, we see that it's very difficult to reconcile investor-state arbitration with other areas of international law. But we need to really think.
Sorry, I'm going to have to cut you off. I did give you an extra 20 seconds.
Okay.
We can follow up on some of those points in the Q&A session.
Yeah, sure.
So it wouldn't be fair to you if I didn't cut you off and I have to cut off Gustavo, who's next. Yeah. So Gustavo will be presenting a perspective on local communities. So this is one of the interests that Mala just referred to that are not taken into account in current investor state and investment law. And his perspective will look at it through investment law, through sustainable development, and through the doctrine of indispensable parties. So over to you, Hugo, or Gustavo.
Thank you very much, Greg, and good afternoon to the audience. Thanks for having me here, and thanks to the Society of International Law, Universidad Externado and Rosario. Thanks to my fellow panelists, Mala, Joanna, and Huaxia. I'm honored to stand before you today as we delve with this issue of international investment law and systematic appraisal and reform. In these passionate works of Jacqueline, courageous advocate of the rights of local communities in Colombia in a place called El Cerrejón, she emphatically states that water belongs to us, not to corporations. Water is for life, water is for people, and water is for the land. So these powerful words resonate with the rights of local communities to protect the interests against foreign direct investors, not only in the international arena, in this international investment, but also domestic with domestic regulation. So my PhD research takes an approach through the fundamental principles of the rule of law and sustainable development. So I argue that first, the international investment system, particularly ISDS, is unable to effectively address contemporary issues and crises like Malacol poly crisis. There is an issue of legitimacy, transparency, and practicability, and it's imperative that we seriously consider alternatives that prioritize the interests of the stakeholders like local communities. It is imperative, as also Mala has explained, a broadened approach. So members, the countries have a broad policy space. And by the way, that is what Colombia is doing and trying to do right now with the renegotiations of free trade agreements and bilateral investment agreements. And also it's crucial to reconceptualize international investment system as one that recognizes the imposition of obligations and duties upon investors. And we have seen also a trend, particularly in the African countries, that they are doing that. So in today's panel, I will try to discuss with you first the concept of local communities as these vulnerable participants in this equation between states and investors. And while international investment may not provide all the answers, I think, and I argue that it should align with the principles of rule of law and sustainable development. And that approach entails a coherent, transparent, non-discriminatory, and open participation throughout the entire investment cycle in national and international settings. And although there have been some improvements, particularly in new bilateral investment treaties and bid models that include obligations for investors and sustainable development clauses and provisions, it is not enough. And recent research also has shown that new generation agreements, including those clauses, have not yet produced significant challenges in investment arbitration. We have seen that in Colombia in the recent Ecuador case. And relying solely on what we have now, third-party participation and amicus curiae briefs is inadequate within the ISDS system, and to enhance the effectiveness and transparency of the system, we need to pursue reforms that recognize local communities as parties when their rights are at stake. And one way to achieve this is by implementing measures that explicitly acknowledge the indispensable role of local communities in investment disputes. And I leave it like that for now. Thank you very much, Rick.
Thank you, Gustavo. And those are crucially important points, which we will get into in greater detail in the questions. So as we heard this morning, these big issues that we're dealing with in the world right now, in the context of this panel, it's simply how does investor-state arbitration fit into these issues? But to fix these issues, we need the collective cooperation of the international community. And of course, that includes China, more than ever, given its role as a source of international investment and its role in the world economy. Our next speaker, Washa, will be introducing her ongoing project of building a database for the UNCITRAL Working Group #3 negotiations on ISDS reform, based on which she will be addressing the issue of whether China is a rule maker or a rule taker on developing alternative means of dispute settlement. One of the things the international community needs to be careful of is to properly interpret what China is doing and what its motives are in these various areas. And speaking with Washa, I got a lot of insight into this issue. So she will now be giving her presentation to give us some enlightenment on this point. Over to you.
Thank you, Greg. It's really great to be here to participate the panel, even though from like thousands of miles away. So today I'm going to introduce my ongoing project about this database on the of the UNCITRAL Working Group 3 reform negotiations of the ISDS, and then I'm going to apply what I have done with the database to a very specific topic, namely the ADR, the mediation as an alternative to the arbitration in investment dispute settlement. Let me just briefly talk about my project first. So there are multiple venues where countries and international community get together and talk about how to reform the investment regimes. So among them, UNCITRAL is probably the most prominent one. And also I got to choose UNCITRAL because unlike the other venues, UNCITRAL is the only international organization that has published all the negotiation recordings, all the audios online. So I'm not part of the Chinese national delegation to the UNCITRAL, more like an outsider, like a very passionate researcher into this topic. So these recordings offer a very rare opportunity for outsiders like me to have an insider's perspective and observation about what is really going on at those multilateral proceedings. So with the help of my research assistants, I have transcribed all the 313 hours of recordings to text. And then we are in the process of encoding those texts, those transcripts. So my goal, my final goal is to build this database where the users of this database can do those interactive research with it, for example, to pinpoint a certain country's position on a certain investment law issue. So, I mean, I myself cannot do that just on my own. I am working with computer science professors at my university, the Peking University, to do this work. So hopefully by the end of the UNCITRAL Working Group 3 negotiations on ISDS, we will also be able to launch this database, which is like can be like used by everyone. And what I'm going to today to present is a very preliminary application of this database. So I chose China and also mediation, not randomly. First of all, as Greg mentioned, China is one of the top investors globally, and also it has this like very ambitious plan under the name of Belt and Road Initiative. Mediation itself has been getting increasingly popular among states as well as investors. That is like considered as more flexible, more cost saving compared to arbitration. And so my focus is on like China's position on this ADR, on mediation. So in general, in the popular discourse, Belt and Road Initiative is considered as a challenge to the existing order of international economic law or international development. So with China's support and endorsement of the mediation would be also considered as like a revisionist approach to reform the investment law. And more importantly, let's just go back to the investment reform negotiation per se. Like, how did China participate in this negotiation? And in particular, how did China say about the issue of mediation in the process of the negotiation? So here's what I found. Everything was based on the audios I found from the UNCITRAL website. So Basically, China was not that enthusiastic about mediation at the very beginning of the UNCITRAL negotiation. It gradually warmed up to this idea. After 3 years, in 2019, that was the first time China brought up this issue to the floor negotiation. And China has not advanced any specific and particular detailed plans about how to promote this idea, how to promote this alternative dispute settlement means. Yes.
Sorry, I have to interrupt you there because again, we've gone over 20 seconds, over 5
Sure.
minutes. So I'm going to enforce my limit, not very well, but there's the 5-minute limit. We can follow up on those issues in the Q&A.
Yes, of course. Yeah.
Okay, so thank you very much. I hope you all were enlightened to some of these points about China that, like me, you weren't aware of. So now we're going to go into a Q&A session where I will pose questions to these speakers. And the idea of these questions is to give you some more insight into the points that they're making. And then I will open it up for questions from you at the end for the last 15 minutes. So Jonathan, I'm going to start with your topic, adopting a domestic law perspective on investment. Why should this audience, which of course is mostly international lawyers or international law academics, be interested in this perspective?
Thanks, Greg. We call that a Dorothy Dixer in Australia. I'm not sure how well that term translates. It's when you're in Parliament and you get your own side of politics to ask you a question for which you've already prepared the answer. This
We're supposed to say that.
Relates to the first kind of claim that I wanted to make out. The short answer is because one way to think about our field is that we're people who are interested in foreign investment governance. And if we think about our field as people who are interested in foreign investment governance, then investment laws are centrally important to that. So we know from surveys of foreign investors, for example, that the national legal environment is vastly more important than treaty commitments in terms of shaping patterns of foreign investment. So it's something we need to take seriously if we're interested in foreign investment governance. Taylor and I think it's interesting in its own right for a range of policy reasons that I'll come to, but I also, I guess, wanted to highlight the intersections with the themes of the conference. So for example, through a study of foreign investment laws, some of the interesting things that we can see are different patterns between developing and developed countries. So some countries don't have an investment law at all. In developing countries, investment laws tend to govern a wider range of issues or perform multiple functions. And in a subcategory of developing countries, there are national investment laws that do look a bit more like investment treaties. And through Taylor's past work, she's shown that's due in part, at least, to advice that's been given by international institutions, particularly the International Financial Corporation, to developing countries to implement national laws that look like treaties. And that's completely at odds with practice in national investment laws in developed countries. So we have really interesting questions there straight away about why is there such a big difference in practice in national law between different countries, and that picks up this developing country theme in the conference. We had a panel on industrial policy. So in some countries, not all, but in some countries, national investment laws are central instruments of industrial policy. They're not the only tools of industrial policy, but through screening mechanisms, for example, investment is often conditionally approved with local content requirements, joint venture requirements. So this apparatus is part of this wider discussion of industry policy, and it obviously also intersects with the security theme of this conference. So if we think about national investment screening, this is the most obvious intersection because it's such a hot topic at the moment that different conceptions of security are being developed and applied through investment screening mechanisms. So those are some of the reasons why I think it's an interesting field to take seriously.
Well, thanks, Jonathan. That was helpful. The lens you're applying in your scholarship captures measures that impact investment, even if they're outside the scope of current investment treaties. And you can see I've got this theme here, which is we need to understand, how this intersection between what Jonathan's researching and international investment treaties is. And Jonathan, can you explain your broader approach? Can it be used to help us going forward in investment treaty negotiations to improve those treaties?
Probably yes, but this is a question I really want to push back quite strongly against, because I think the first move we need in this field is just to let go of some of our assumptions that come from investment treaties. So if we start off seeing investment treaties as the central legal instrument in foreign investment governance, then we tend to look at everything else through that lens. And so we ask questions like, what are the standards of protection in this particular national investment law? What sort of dispute settlement arrangements does it set up for investment disputes? Okay, so those are interesting questions, but they are questions that are vastly too narrow. So if we look historically, investment laws predate investment treaties. So that's one reason for looking at investment law in their own right, rather than seeing them as a subcategory of treaties. In terms of the content, and this relates to our functional approach, if you look at the content, they're wildly diverse. There are, and this is in the paper, there are clusters and patterning within investment laws over time and geographically. So it's not just random. An important part of the contribution of the paper is to begin to make sense of that patterning. But if we distinguish the laws from investment treaties, there's no equivalent to that templating where we all intuitively have a sense of what is roughly a standard investment treaty in terms of provisions on expropriation, national treatment, FET, ISDS, that sort of stuff. So they're wildly diverse and they perform different functions. So as well, some investment laws do deal with investment protection. Some do specify dispute settlement arrangements. Many don't. Many of them, perhaps the most common function of national investment laws is governing the admission and approval of new foreign investment. And that's a really centrally important function to take seriously on its own terms. But they also have roles in facilitating investment, in specifying investor obligations and responsibility, in performing monitoring and oversight functions, or establishing institutional apparatuses for monitoring and oversight. And so we need to, and incentives, which is historically, even though it's a super problematic function, is historically a function that's been very common in developing country investment laws. So I think I would like to park the investment treaty questions, and then at the end of the presentation or the research agenda, there might be some implications, but the key message is that there's real insight to be gained from thinking about investment laws seriously on their own terms.
Thank you, Jonathan. Now, can you give an overview of the benefits of your approach? And if possible, discuss how the industrial policy that was raised in the first roundtable today fits into your approach?
Sure. So what I'll do here is I'll speak to the fourth claim I wanted to make out here, which was to use the example of the function of investment laws of governing admission and approval of new foreign investment. So to use that as an example to show some of the payoffs that we think you can get from thinking about investment laws in a serious way. And this sort of begins to introduce our approach of sort of identifying clustering historically and geographically to track movement. So let's start in the 1960s in Africa. So we're in the era of decolonization, and there is a huge wave of new national investment laws, mostly adopted very shortly after independence. So these were seen as very high legislative priorities for the governments involved, which almost have a kind of quasi-constitutional function in that they're setting out a vision of the relationship of the state to the market. And that vision is developmentalist broadly in these laws. So these laws, we can see them as instruments of national economic planning and developmentalism. They've got almost nothing to do with investment treaties as they exist today. Rather, one of the central functions common to these laws is that they establish systems to govern admission and approval of new foreign investment. And so in these laws, of which Botswana is one of the examples we look at in the paper, the broad outline is foreign investment requires approval. So in principle, foreign investment is not allowed unless it's actively approved. The law constitutes a board or a committee to manage the approval process. That committee is generally constituted through an interministerial arrangement, which reflects the developmentalist ethos, the kind of industrial planning ethos, and insofar as criteria for approval is specified, which they were to some extent in Botswana, they very much reflect this developmentalist ethos. Then moving to the 1970s, we can identify a different cluster of national investment laws that emerge almost simultaneously in New Zealand, Canada, and Australia. So this is interesting. Developed capital importing countries. That's important. Developed capital importing countries. And these laws are focused almost exclusively or exclusively on investment screening. So they perform the function, the core functioning and governing admission and approval of new foreign investment. There's real continuity with some of the African laws in that they establish new centralized institutions for the screening of foreign investment. That screening process involves discretionary review against abstract criteria, generally national interest or net benefits. Decision-making power is vested in the political level, acting normally as a practical matter on advice of the institution that performs the screening function. But there's a real shift if we compare that to the African story of the 60s, in that these laws are operating against a background assumption of openness. And there's a bigger story in the paper about the politics and the domestic political economy of these laws. But basically, the assumption here is that in principle, the state is open to foreign investment, but investment over certain thresholds or subject to certain triggers has to be screened against these criteria. And in Canada and New Zealand in particular, there's a very explicit tie-in of industrial policy to the conditional approval of foreign investment through those processes. So that's a development in time. And then let's skip a couple of steps. There's more in the paper. But this gives us a bit of leverage over the current debates about supposedly new, not that new, investment screening, which has emerged in the 2010s, particularly now in Europe underneath the EU directive for investment screening. So lots of states are setting up new investment screening mechanisms. So it's not the same, right? There are really important differences. These mechanisms are generally focused on applying criteria of national security in the screening process, although national security is often conceived of broadly in a way that picks up some of these sort of technological concerns, these quasi-industrial policy concerns that were also central in the 70s and 60s. So we see continuity there. And then there's clear sort of continuities in institutional form, in the sense that you have these committees being constituted to review investment that meets certain triggers against discretionary criteria. Greg has drawn attention to the fact my time is out, and that's where I wanted to round out that story. Yeah.
Well, thanks, Jonathan. That was great, great insights. So over to Mala, and just to tie your research and presentation into Jonathan's. As you said, your research focuses on a legitimacy crisis and a poly crisis facing investor-state arbitration. You argue that current reform proposals address, to some extent, the first type of crisis, but not the second One example you provide is that the limitations of investor-state arbitration, those limitations will impose limitations on policy solutions to the climate change emergency. So can you just comment on how you believe Jonathan's domestic investment regimes fit into your analysis?
Yeah, sure. Thank you, Greg. Thanks for the question. Well, I think in terms of what Jonathan has said, he clearly brings out one thing very strongly, that national investment laws are very, very important part of the whole system, right? And when we think about these emerging crises, such as climate change, we know that some of the responses will be within domestic laws. States will inevitably have to do or take measures domestically. And I wanted to highlight the interaction of investor-state arbitration with domestic laws, for example. Now, it is, as some of us may already know, we know that every time an investor brings an investment claim in one particular, as against one particular state, it sends a signal to other states that something like this they might be involved in something like that. So for example, let's take the plain packaging of cigarettes. When Philip Morris sued Australia, New Zealand delayed bringing in similar measures, and so did UK. So when we see initiation of investor claims, we see that states sometimes become reluctant to take those measures. So in terms of investor-state arbitration, it kind of intrudes into that domestic space by creating a sort of a regulatory chill. Now, some commentators have mentioned that this might actually be a good thing, in the sense that you can actually then use investor-state arbitration as a way to improve governance and possibly even their own environmental measures, for example. And we have the case of Allard and Barbados, where, for example, the investor brought a claim against Barbados saying that their failure to keep up with their ecological laws and environmental laws caused him harm. But we need to be a bit more careful when we frame things like this, for the simple reason that just because an investor has brought a claim doesn't mean it will compel the state to do something in the right direction. And the investor is eventually bringing the claim to further their own interest. So it's not that the investor really cares about the environment, it cares about that its investment is affected. So what Jonathan said is, yes, the domestic part is very important, but I also wanted to highlight the intersection and the interaction of investor-state arbitration with the domestic regime, particularly from the lens of regulatory chill.
Well, thank you very much, Mala. My second question relates to the current reforms to investor-state arbitration procedure. And your view is that these reforms are inadequate. Can you please explain the basis for those views?
Sure. So I think that the reforms that are currently ongoing at the UNCITRAL Working Group 3, if we look at them a bit more deeply, we see that most of them are fairly incremental in nature. So for example, we had criticism against the system that arbitrators were not regulated, and now we have the code of conduct for arbitrators. And initially, in fact, transparency, for example, was one of the first that was kind of worked on. I think the work started within ICSID in 2006, and then it flowed over to UNCITRAL, and that culminated into the UNCITRAL transparency rules and the Mauritius Convention. So that was probably one of the first. But then even if we look at that, we see that whilst non-disputing state parties got some rights to participate, the amicus submissions part is still fairly within the control of parties. So if disputing parties don't want third parties to intrude into proceeding, they can actually stop it even today. So what has really changed from then to now? Then if you look at even the other other measures. For example, there have been talks about having the multilateral investment court, but we see very little political will apart from the EU. So all of these reforms that are there, particularly the incremental reforms in terms of regulating arbitrators or bringing in more transparency, I think they, to some extent, they counter the legitimacy crisis of investor-state arbitration, but they're certainly not enough. If you think about investment regime broadly, because it does very little in terms of imposing investors' duties, it does very little to reconcile it with other areas of international law. And there is some work ongoing in relation to damages, but I can only speculate as to where that is going to go. But even then, even if, say, UNCITRAL comes up with some sort of guidance for arbitrators will still have a lot of discretion. And it is very necessary that we find a way to make sure that this discretion is exercised in a way that they defer to the authority of the state. I'm not saying make pro-state interpretations of things or give pro-state interpretation of things, but it really, really needs to consider the systemic impact of their award and no longer look at arbitration as an isolated ad hoc, dispute settlement mechanism, but rather it being an entire system that really has a serious impact. So for these reasons, I think that reforms are mainly procedural, and even when they are a bit substantive, those incremental reforms are not really enough, according to me.
Thank you, Mala. My next question relates to the spillover effects that investor-state arbitration can have on legitimate domestic policies, and how the poly crisis you identify that's created by these spillover effects can be addressed through the three fundamental calibrations that you have identified.
Sure. So when we talk, so the three fundamental recalibrations I spoke about, the first one is allowing states to undertake measures to deal with, say, climate crisis without having to pay investors exorbitant compensation. Now, if we don't do that, we're going to land up having more cost for energy transition. It is not going to make the state do something in the, it's not necessarily going to make the state do something in the right direction. And of course, the whole prospect of regulatory chill remains. In terms of the second one, that we need to, or let me take the third one first, in terms of reconciling it. What happens if we fail to reconcile investor-state arbitration with the other areas? Well, for one, investor-state arbitration is not an isolated mechanism. If we think about it so exclusively, it is almost impossible to think about anything good that can come up, because investor-state arbitration will always sort of be an obstruction. And there is, and also we see this increasing privatization of things, right? Particularly essential services. Eventually, we will have several arbitrations. We have had them in the past, and we will probably continue to have them, where essential services, once they are privatized, they will not, it will not just be about the state and the investor. It will inevitably have third parties who will sometime, probably they won't even have a say within the proceedings. So it's very essential that we think about reconciling investor-state arbitration with other areas to kind of, prevent the disasters that can happen because of the spillover. And in any event, I think it's good for investor-state arbitration to have some sort of consistency with other areas of international law. And come to think of it, what if investor-state arbitration was not there? Then in all likelihood, we would have domestic courts litigating, these cases being litigated in domestic courts, and they would inevitably at least try and balance these competing interests and balance human rights, they would not disregard these kind of arguments. So I think those are some of the ways in which we can sort of, if we don't really address the problem, those are the kind of spillover effects that it will have. And talking about my last, that was basically my second point, is that investor-state arbitration, it needs to be reconceptualized as a system that recognizes, imposition of investor obligations and duties. Well, this is again very important because foreign investors, because currently there is hardly anything very concrete that imposes any obligation on them. And when I say this, I sort of think about, the Union Carbide case back in India. We don't necessarily have to wait for a disaster to happen. We can take proactive steps. And well, we've started the movement. We do see some treaties, talk about investor obligations, particularly we have some investor obligations within the Morocco-Nigeria bilateral investment treaty of 2016. But strangely, we don't see any in the 2020 Morocco-Japan bilateral investment treaty. We see some in the Pan-African Code. We see it in the South African Development Community Model BIT. We see some obligations within the Belarus-India BIT, to name a few. But they're there. But how far will tribunals really interpret them the way they should be? I'm not sure. Secondly, the question of remedies. Can you really have specific performance as against an investor? And what about situations when you can't really have specific performance? So what happens if an investor does something that, for example, degrades the environment? And of course, you might have some, corporate social responsibility provisions within your company law or domestic legislation, for example. But is that really enough? So, yeah.
Sorry, but I do have to cut you off, but
yeah.
That was a great presentation. Thank you.
Thank you.
Now we're going to our next speaker, Gustavo. And I'd like to start with a question about the focus of his research on local communities and the failure of the ISDS system to take their interest into account. Is this yet another example of the poly crisis that Mala was referring to?
Absolutely. It's another very good example. And a parenthesis on the issue of domestic laws, and I think that is very important. On my research, I should be that is the most important tool for local communities. And screening mechanism there, and they should include provisions also local communities like Australia and Canada are doing. The right of consultation, free, prior, informed consent also is there. However, we have they harmonize the concept of consultations, impact assessments, also should include social values. And we have also a trend that impact assessments are not about social values. So I believe that international investment law is a success story, and they are a useful tool for investors. And if we cannot get rid of them, let's reform them and make them useful for other stakeholders, such as local communities. Sorry for the points.
Thank you. Now you talk about local communities. Can you elaborate upon what you mean by that?
Absolutely. And I just take advantage that my colleague Machi is here. This is a concept that we have been discussing already 3 years. Now I discussed with him, and he believed that with other authors that maybe it's not that relevant or necessary to define them. And it could be any community. If I am mistaken, please correct me. It could be any community affected by the investment. I believe that there's, at least from my research, there is a need to define local communities in this interaction equation between investor and state. And our research encompasses an extensive geographic scope spanning from regions as Canada, Latin America, Australia, Africa. And what we have seen is that local communities lack of legal definition, like mandated definition, and as the case of indigenous communities. So it makes it challenging to establish a clear framework for their protection. However, there are instruments there in other areas of international law, like the Convention of Biodiversity, especially Article 8A that provides for the obligations to protect local communities and indigenous communities, or the guidelines for discussions concerning local communities with the context of the convention, which give us some features. And those features are, among many others, self-identification, definable territory, territorial economy activities, right to natural resources, and vulnerability to outsiders. Another legal instrument, very recent and very current for Latin America, is a regional agreement on access to information, public participation, and justice, of the agreement of Escazú, that defines also the term local communities, persons of group in vulnerable situations. So this includes, and part of my research includes workers, migrants, former combatants in transition justice procedures in Colombia and somewhere else, peasants, indigenous peoples, ethnic communities, and public services users. They may be also affected by the relationship between the state and foreign investors, requiring attention to human rights, labor rights, access to resources of water, Jacqueline, equality of public services, right to information, and other rights. So local communities often face difficulties in exercising their rights, and vulnerabilities can arise from the relationship with states, remoteness of the territory, and lack of legal representation. So international investment law could enhance the right exercise if the rule of law is applied. So in general, what I mean and what we mean by local communities is vulnerable communities.
Thank you, Gustavo. You mentioned rule of law. So in the context of local communities, what do you mean by that term?
Thank you, Greg. And in my research, I take a broad and regional and holistic approach of the rule of law that is no longer this abstract concept that we see, the formal, the substantive rule of law. Now there is international instruments that define the rule of law somehow. The United Nations Resolution 76, the rule of law at the national and international level. So I take the approach of that UN resolution, and also the Sustainable Development Goal 16, access to justice. So these legal instruments demonstrate that the rule of law is no longer this abstract concept, but a concrete legal principle that could be defined within the following 6 definitions. First, a just, fair, and equitable law, protection of the law without discrimination. Second, effective, just, not discriminative, equitable delivery of public services, including criminal, civil, administrative, judicial system, and legal aid. Third, equal and effective access to justice. That is also embedded in the Sustainable Development Goal 16, peace, justice, and strong institutions, and the target 16.3, access to justice for all. Fourth, independence, impartiality, and integrity of the judicial system. Fifth, coherence and consistency are required both at national and international levels. And finally, transparency. So it involves the communication of information, allowing individuals to participate in decision-making processes and giving consideration to their concerns. So thus, in the investment scenario, the rule of law should apply to domestic and international law related to foreign direct investment, considering local communities as these vulnerable communities or participants in the relation between foreign direct investment and the state. So this might be relevant in the entire investment cycle, the pre, post-establishment, acquisition, expansion, operation, management, maintenance, sale, disposal of the investment, and of course, dispute resolution.
Well, thank you, Gustavo. So there's been a trend in new investment treaties to address current issues. One example being the environment. How have these new treaties also addressed local communities?
Yes, absolutely. There are nowadays not many, but some bilateral investment treaties and bilateral investment model treaties, especially in Africa and also in some European countries, that include provisions related to corporate social responsibility, labor rights protection, mechanisms for addressing violations, including previous mechanisms. They also include provisions related to cultural identity, mostly in Africa, and diversity, gender equality, indigenous rights, inclusive trade, and traditional knowledge. They also commit transparency and information sharing, including disclosure of impact assessments, obligations for investors to contribute to communities, to the community development and financial support, and also provisions related with third parties in DS, so such as the Dutch model bilateral investment treaty that allows also for the Amigos Curia brief to be taken into consideration by the tribunal. But what this mean for the local communities in practice, in real terms? So currently, as the system works, nothing, because those provisions are provided in the preamble and some parts of the treaty and or the exceptions, and usually are not covered by dispute resolution clauses. And also research has shown that in the inclusion of these sustainable provisions in ISDS in practice, they don't have any effect. So what we have now, procedural tools with limited scope. Some arbitration rules allow for the participation of third parties, hearing and written submissions, but if the parties and the tribunal agrees, sometimes that's not the case. And we have the recent case of Ecuador. And in general, local communities are not considered to be third parties in disputes. And usually NGOs want to contribute as third parties, but they are not allowed to participate. It's very difficult for them because arbitration tribunals do not accept them, and parties of the procedure do not acknowledge them. So this is the case of Ecuador.
Well, thank you. The final question pertains to the reforms that you would propose to address this deficiency.
So absolutely, yeah. What my research proposes, and many other things, including domestic law reform, is reform in international investment agreements. So local communities are naturally accepted as possible third parties when an investor claims a violation of a treaty provision that also relates to local community rights. I propose a similar institution that the International Court of Justice has in the monetary gold and its Timor case, so the doctrine of indispensable party. So the doctrine of the indispensable party is a recognized procedural principle of international law, basically between in disputes between states, and it states that the entity affected by the subject matter of a dispute must be a party to the legal proceeding for a court or a tribunal to have jurisdiction. So applying the doctrine to the local communities in investment treaty arbitration proposes a reform that considers them as necessary parties in the dispute. And if local communities' rights or interests are at stake, the tribunal should include them in the proceedings. So through the representative NGOs or legal aid that is provided by the state, local communities can actively participate by submitting written submissions, presenting oral arguments, and engaging in relevant proceedings. This may uphold the principle of inclusivity, the fairness, and of course the rule of law, ensuring that the local communities' rights and perspectives are safeguarded. So how am I with that? Okay, in conclusion, so it is clear that local communities play a vulnerable role in the investment-state relationship. Therefore, adopting a rule of law approach to local communities within both domestic and international investment law is essential to safeguard their rights and protect their interests. While international investment law may not provide all the answers, it should align with the principle of the rule of law, and the rule of law approach entails a coherent, transparent, and non-discriminatory and open participation throughout the investment cycle in international and national settings. And although there have been some improvements in international investment law, particularly the new BIDs and BID models that include obligations for investors, it is not enough. It is not enough. Recent research has shown that the new generation agreements are not producing any significant change, and rely on the third party and ambiguous participation is inadequate. So that's why I propose the doctrine of indispensable party to be applied to local communities. Thank you very much.
Thank you, Gustavo. Obviously, this is a crucial issue when we look at the Amazon. I had the fortune of spending 3 days there before I got here, and local communities are just absolutely indispensable in that area. So to our final speaker, who's been up the longest, it must be around 4 a.m. there in Beijing. Guosha, your research focuses on mediation as an alternative means of dispute settlement to ISDS. Is this an example of a reform to address the legitimacy crisis referenced by Mala in her research?
Thank you, Greg. Yes, for sure. Well, first of all, I would like to say that mediation as a means of dispute settlement has always been there. So not necessarily just for investment disputes, but like for international disputes in general. Think about the UN Charter, as well as the ICSID Convention in the year of 1965. Both included mediation or conciliation as a means of dispute settlement. But for the investment dispute settlement, mediation has for a very long time been overshadowed by arbitration. So we like when I was a law student, I tended to take arbitration as a default mode of dispute settlement, and then did not even think about alternative means. So why mediation like now? Why so many developing countries, developing countries as well, and including some international organizations and international the non-governmental organizations, why they're in favor of developing the ADR. So I would say that mediation or conciliation can address quite a lot of the legitimacy problems or crisis. For example, the procedural problem in terms of the representativeness of those arbitrators. So mediation was largely driven by the voluntary behaviors and the wills of the parties at this specific disputes. So it is like the countries at this disputes, they have more say about how to organize, how to orchestrate the whole mediation process. And compared with the arbitration, the mediators play a lesser role as compared to the arbitrators, who in general have lots of discretion in the proceedings. So in that sense, mediation can partially address the procedural legitimacy crisis. Substantively, I would argue that mediation could also, to a certain extent, alleviate the developing countries' concerns about the bias, the prejudice that the current arbitration system would probably have against them. So we have read lots of studies and scholarship about like arbitral tribunals being kind of biased against developing countries. they tended to engage in more like broader interpretation of those investment treaties favoring the foreign investors when the respondents are developing countries, or the ISDS outcomes are more like, or like the developing country respondents were like twice as likely to lose a case compared to cases against developed country respondents. So cases like that. So the mediation proceedings, they are less adversarial, they are of this voluntary nature, and in general, developing countries would like, I would argue that would tend to be more accepting this less like imposed and adversarial means of dispute settlement as compared to arbitration. And this is also in line with the overall discussion about judicialization and dejudicialization of international relations and how the developing countries in particular have been responding to that in particular within the dispute settlement area.
Well, thank you. My next question relates to an observation in your paper that the reforms being considered do not fully account for the Chinese perspective, which you view as a significant deficiency given China's high level of foreign direct investment. Why is China's position in these reforms so important? Can you elaborate upon that?
Yes, of course. Well, first of all, the sheer amount of China's overseas investment that warrants like heightened attention to China's position on any reform proposals on the ISDS. And on top of that, I would argue that if you look at China's BITs and also China's investment treaty making practices in recent years, you would notice that there is a very big gap between the China's BITs and China's investment drive. So many of the investment agreements China has with those, especially with those Belt and Road Initiative partner countries, they were signed in the late 1980s and early 1990s. That they are what we call a first generation and second generation of China's BITs, and very limited protection when it comes to dispute settlement. So that is why, I mean, considering how long it takes to renegotiate those BITs, China would put like more efforts in the multilateral reform area and try to compensate for the lack of protection under the existing bilateral investment agreements. And a third reason, I guess it had a lot to do with geopolitics or the general like perception about China when it comes to international law and international relations. So China is not a big fan of the judicialization of international relations, with the exception of the WTO. I think in most areas of international law, the Chinese government position is that it does not accept this compulsory jurisdiction. I mean, in China's foreign policy practice, China is also very big on mediation. Think about the recent deal China brokered between Iran and Saudi Arabia, and China's mediation efforts in, for example, in Afghanistan, in Libya, and also China's most recent proposal to establish this new international organization called International Chamber of Conciliation or something similar to that. So China is not a big fan of the ICJ or other like compulsory dispute settlement mechanisms. And alternatively, China would resort to mediation. So I would argue that with the massive investment drive under the Belt and Road Initiative, and taking into consideration of China's reluctance to participate in third-party adjudication or arbitration at the international level, I think what China proposed or will propose at the UNCITRAL Working Groups 3 or other multilateral venues in terms of on the issue of investment reform. I think all of them are very important based on the previous three reasons I just mentioned.
Well, thank you. Just for the audience, we started 10 minutes late, so I hope it's okay if we go over 10 minutes. My last question is, can you discuss your research and how it will shed light on China's position on mediation? And just to remind the audience, 300 hours of minutes were transcribed. That's the data. And the question is, how will this research shed light on China's position, including China's limited engagement on mediation during this period?
Yes, sure. So this has a lot to do with what Jonathan just mentioned about this comparative approach to the study of investment law. So instead of just looking at China's position on mediation from this outside or from this international perspective, more structural perspective, I opted to look for explanations from inside. So two reasons I would argue that explained why China has been very hesitant in endorsing mediation at the UNCITRAL Working Group 3 negotiation. The first has a lot to do with China's domestic legislative framework. So, we know that China is among the first batch of countries to sign on the Singapore Mediation Convention, but China has not ratified that. So why is that the reason? So the Singapore Mediation Convention was to address enforcement problems of the settlement agreements, right, arising from the from mediation. But China's existing legislative and judicial practice provide no such applicable rules or guidelines on like the settlement agreement as defined in the Singapore Convention. So there is like quite a big gap or mismatch between China's international commitment and what China could be able to do domestically. And also, I mean, in terms of capacity, China does not really have many like talents who are capable of doing this like transnational mediation things. So that is another thing. An even more important domestic reason to look at is about China's state-owned enterprises and its role in China's overseas investment drive. So especially under the Belt and Road Initiative, I would argue that over half of those investments are made by state-owned enterprises. And in Chinese politics and judicial system, the senior SOE management officials, they are not just like senior managers within a very big company. They are considered as public officials under Chinese law. So those officials, they are very afraid of like corruption charges or the charges about like loss of state assets, because if they go out there and negotiate a mediation deal with their counterparts or with another country's government, and if domestic politics or domestic audience feel like this is like not a good deal, there is a chance that those SOE managers can be punished by law. So they know that mediation is actually much better in terms of like settling disputes in practice, but they would still prefer to go for the arbitration, the traditional track, because if it is an arbitration, they're less likely to be punished by domestic law. So this like domestic accountability mechanism is another very big obstacle that prevents China to be more assertive when it comes to developing ADR on the ISDS issues. So again, we need to go back to the comparative law reasons to see why China hasn't been so enthusiastic about mediation when all the international explanations would predict that China would do something different. China is as an authoritarian regime, would go for mediation, less about rule of law at the international level. So that would be my explanation.
Well, thank you very much. Time is marching on, so we're going to jump right into the audience Q&As. Yes, so put up your hands if you'd like to ask questions. Okay, so we have quite a few. Are there any online questions? Do we have any questions from the online audience?
We don't see that from my end.
No? Nothing? Okay, great. Okay, so put up your hands again. Okay, so we're not going to have time for everyone, so we need to do a random sample. I'm thinking 3 questions. Up front, in the middle, and then who's back row again? Hands up. Oh, actually, no, we'll go that way. We'll go right, just to be fair. Are we okay if we go over?
You don't mind, we can spend.
I don't mind.
If we keep it short, we can hear at least all the questions.
So new plan, so we're going to start at the back row and hand it up till it gets to the front. How's that? I just don't want to be offside for the bosses who put me in this position.
That's the boss.
Yes.
Oh, you're the boss.
For here, for in between the poster sessions and introduction to Robert Hudek for 15 minutes, so we can spend 15 minutes more, but this keeps short at the.
Yeah, I just want to remind everyone too, I was also instructed to inform you that there will be a book presentation by Jennifer Hillman and Henry Gao on teaching international economic law.
We know.
Following this. Oh, you do know?
Yeah.
Okay, good. Well,
program.
then we're good to go.
No, but they will delay their presentation for 15 minutes at least.
Perfect.
Okay.
I'm used to appearing before ISTS panels. They're never this nice. Okay? So thank you.
Okay, you go ahead.
Okay, so we'll start over here and then pass it down.
Thank you very much for a fantastic presentation. I have actually 3, short question. First question goes to Jonathan. Jonathan, thank you very much. I will read your paper with John Taylor very soon. But my question is about your, research method. How could you cover all domestic, investment laws? Because I know my country's Uzbekistan laws is investment law is so big. And another point is that some countries' investment law is so short, and they leave details to the bylaws. Then how did you get a balance? And in case of, for example, Japan has only foreign exchange law, so it's not a purely a domestic investment law. So how did you get a balance? So this is the first. And second question is for Washia from the Peking University, I think. Thank you very much for your presentation. So I have a bias. If the China, prefers mediation over ISDS and there's a domestic accountability pressure, then recently on the May, the President Xi stated in a Xi'an summit that we want to update our BITs with Central Asian countries. And so if the China does not want ISDS, and if China prefers the mediation, why China wants to update its own BITs and why Xi Jinping wants to update its their BITs. So can we understand that in the near future, Chinese SOEs will use ISDS alongside BRI against its own partners? So this is second question. And third question is to the Gustavo. Gustavo, thank you very much. Recently, one of my excellent colleagues from Japan, Tomoka Ishikawa from Nagoya University, published a book in Cambridge University Press called Corporate Environmental Responsibility in ISDS, the Unexhausted Potential of Current Mechanisms. And inside that book, actually, I reviewed it for the Japanese yearbook of international economic law. She used the concept so-called social license to operate during the investor's performance phase misconduct. So if you have any evaluation on this concept, I want to hear your idea. Thank you very much.
Okay, so again, short questions. Thank you for your short questions. One question each. and we'll accumulate all the questions and then respond. So next, over to you. Yes.
Yeah, so just one rather short question for Jonathan again. So I was very interested in your work on the national laws. I was also having a look at the report during the panel. I have a question about to what extent do you think that national laws can serve to incorporate sustainability and climate change considerations and thereby also address some of the concerns of investment treaties? Reading your report, I briefly found only something on former Soviet republics, and you had examples of Azerbaijan and Mongolia, I think, how they introduced rather stabilization clauses in the national laws, which prevent the state from making the changes for climate change, for instance. So I wonder if instead national laws can go against this trend and in the 20th of this century, facilitate the screening of investments based on those considerations. So that would be the question. And I'll go to Ganesh.
Oh, I actually have a question for Jonathan as well, but I'll take it vis-a-vis, it's fine. So I'll ask a question to Mala instead. Very brief question, why a polycrisis? Because the way I see the current legitimacy crisis unfolding, it is already a polycrisis. The very fact that there is a, let's call a procedural reform that's ongoing in UNCITRAL versus there's a lack of substantial reform shows that there are multiple strands of crisis already. So maybe I'm reading the terminology wrongly. Maybe you mean something else by this. So what exactly, like, do you expect it to sort of proliferate further or like spread out further or trickle down? So that would be my question. And I will also like get in touch with you about the UNCITRAL process because I have some firsthand insights that you might be interested in. As I'm an observer there, so that's why.
That would be great. That would be great.
Sorry.
Thank you very much for the presentation. So I also had a question for Jonathan, who we can talk later. For Gustavo, the definition of communities, I mean, all your presentation and your research is based on a more ethereal way of defining the communities, but why don't you go to international human rights law and what does that mean? No? And also specifically regarding peasants and Colombia's position with peasants lately, no? And the recognition of peasants in the constitutional system.
And the last one right here. Right. Sorry, two more. Okay. Yeah,
just one question, I guess, both Mala and Gustavo might want to jump in. So a common pattern is the reconciliation between human rights and other areas of public international law and investment law and through arbitration. And ultimately, the question is, do we trust this development of these areas of international law to the hands of arbitrators, of investment arbitrators?
I have two quick questions. So one is for Huasha. I really enjoyed your presentation, but I was just curious about one aspect of your research because you seem to be saying that there is all this emphasis now on mediation and that China is part of this move, and that you're addressing this by reading the UNCITRAL debate. But I was puzzled by the fact that as China, it might be true that China is pro mediation, but also we know that from the Belt and Road Initiative projects that they also rely heavily on commercial courts, right? It's an instrument of Chinese the Chinese approach. So how do you explain that? Is it part of like a package, or you're saying that it's mediation, either mediation or these other practices that we already know? And my second question is to Jonathan. I really like the project.
Sorry,
it's yeah. Okay.
we're really going to run over here. Washa, could you go first since you're the latest?
Yes, sure. Thank you, Greg. And thank you all for your great questions. Well, I will start with the last question addressed to me. So the Chinese government puts very heavy emphasis on developing commercial courts and arbitral institutions in settling disputes. And how would that be reconciled with China's position on the mediation? So I would argue that, yes, they are within a whole package. And I'm not part of the Chinese delegation to any international organization or multilateral negotiation, but as a Chinese national, and also I study international relations on top of international law, my understanding about China's position on a specific issue is that it is never just one single voice. And different parts, different branches of the government has their own preferences, would advance their own interests in making the decision. So, for example, maybe the Ministry of Foreign Commerce and would prefer to see more institutionalized mechanisms like commercial courts and arbitral institutions based either in Hong Kong or in Beijing. But like the Ministry of Foreign Affairs, they would in general like China to be seen, to be taken as a more conciliatory like a figure or an actor in international relations. So it is not just one voice, and they're both there. And that is why in my paper, I would like to, I argue that even though China has put forward mediation on many occasions, not just on investment dispute settlements, China's practice on mediation, China's hands are actually constrained from a domestic or comparative law perspective. And also that is related to the very first question I got. Why did Xi Jinping emphasize on updating the BITs while China is still talking about mediation? I think he or his aides fully understand it's very difficult to renegotiate or update the BITs. So the wiser, smarter way of doing this is to do both and see whichever works in China's interest. So I also got a question from online. Can I address that, Greg?
Certainly, given you stayed up so late for us, please.
Okay, so it's very quick. So that concerns the methodology of my research. So I'm only looking at the transcripts and the public records of different countries. So wouldn't that be introducing bias into the result? Yes, of course. I fully acknowledge that this is like the only public data I could get, and I'm not saying that this is the whole picture. So thank you for the suggestion. So in my future research, I will definitely make a note of that. Thank you.
Well, thank you very much. Mala, could you respond to your question, please?
Yeah, sure. So I think I had two questions. The first one was why I chose the term polycrisis. Well, we know that, and I think Gunesh pointed it out, that the crisis around investor-state arbitration is already so much. So yes, I guess the polycrisis is just another way that we can frame this. Polycrisis, the idea behind polycrisis is that crisis within one system has spillover effects on other system, as a result of which it degrades humanity's prospect to deal with the situation. So yes, for example, we have a legitimacy crisis, and say we think in terms of normative legitimacy and say that, you know, third parties are not allowed. And for example, if we take the normative attribute of participation and transparency to be something very important, we know that, you know, if you don't have that, it is legitimacy deficit in the normative sense. But then when you are not allowing third parties to come into the proceedings, for example, in a dispute relating to environment or in a dispute relating to, say, for example, climate mitigation, maybe you're not allowing submissions by an organization which has a lot of insights to offer. At that time, you are preventing an indispensable party from participating. Also, in many ways, by your failure to integrate things, you are increasing the cost of energy transition. So we already have this legitimacy crisis, which has spillover effects on the climate crisis. So that is how I use the term polycrisis. The second question was around if arbitrators are the right people to decide issues of public importance, if they are the right people who should be deciding on human rights issues, for example. Well, the answer, it's difficult to give an answer in yes or a no, that they are the right people or they're not the right people. But the fact is, despite these reforms and despite some countries sort of moving away, investor-state arbitration is not going anywhere. It's here to stay. And arbitrators will continue to decide on these very, very important disputes. Are they the right people? I am not sure. I wish we would have more momentum for and political will for the multilateral investment court. Maybe things would be different. Maybe, you know, tenured salaried judges can do a better job in terms of reconciling things. But for the time being, this is what we have. We have investor-state arbitration. And are arbitrators the right people? Maybe not. But if I think they start exercising their discretionary powers, and they can do so using the tools embedded within the VCLT, if the arbitrators exercise their discretionary powers in the right direction, I think they could be the right people. So it would, so to answer that question, yes and no. It shouldn't be, but that is all that we have for the time being, I guess. So these were the two questions. So I think I will let Greg take the floor again.
Thank you, Mala. And now over to Gustavo, if you still remember the question.
Yeah, of course. Very direct questions and very straightforward answers. On the issue of social license, yes, we analyzed the issue of social licenses in my research, and we found that there is not an international instrument that define social license. There is a similar instrument, which is the consultation, that also regulated by other international agreements, and these also have been discussed in the arbitration of Creek Mining versus Peru. So that they arrived to the conclusion that when they refer initially to consultations, so the claimant referred to social licensing, they were referring to consultations, and internal regulation that regulates consultations. On the question of peasants, but thank you very much for the question. Actually, yes, I take into consideration the concept of peasants, and which is in the United Nations Declaration of Human Rights, especially Article 5.2, where it also includes farmers, small-scale agriculture, complaining, livestock raising, pastoral fishing, forestry, hunting. All those communities are local communities because they may be vulnerable. So my approach is a little bit broader, and I think it makes sense if we take the vulnerability approach. And on the question on the hands to international arbitration, I may disagree a little bit with Mala here. I think that they should not have the power to make these decisions. And I think that's why we need to reform. And I think that's why we are trying to reform, at least from the Colombian perspective. That's what I have been working on. We are trying to be explicit on the clauses that we need to apply, the obligations that we need to apply to investors. And at the end, they will have a very narrow scope of interpretation. And that's the aim. And that's what I think from my research is what we should do.
Well, thank you, Gustavo. Now, I hope Jonathan has had time to come up with answers to that myriad of
Well,
questions, the waterfall of questions.
I get
that we
it.
had.
Yeah, thank you. And I'm very happy. In fact, I would love to continue the discussion afterwards. So if my answer is too short or anyone who had a question, please, let's talk. So Alicia's question, there's a big one about how to define the field. And we don't have an easy answer to that. So you're exactly right. There are many, many investment laws, probably about 200. Not every country has one, but some have two. And then there's change over time, and then there's regulations made under the laws. So what can we do with that? Well, there's already the UNCTAD database of all the existing investment laws. That was the kind of starting point and helped us get a handle on it. In terms of the historical research, we've been trying to identify different clusters in different times and different locations. Often when you start looking in one time and location, that gives you a sense of trajectory about what came before and what came after. But we can't claim comprehensiveness. In the best answer we have, I think, is a pragmatic one, is that there's already a field of study, a very small one, but of people writing on national investment laws. And what I hope, without being conceited, what I can say is the ambition is to do something that's very significantly more comprehensive than anything else that's been done before. So that the ambition is to improve rather than to claim to cover everything. And then, so, is Japan's investment law an investment law? So yes, the foreign exchange and foreign trade control law falls within our definition of an investment law. We have in the IASD paper, we have a bit more about how we try to define the field, what's in scope, what's out of scope. That's in scope because it's a law that's addressed specifically to investment. It's a really interesting story because the screening mechanism in there is structurally similar to the 1970s cluster that emerged in other developed countries, Australia, Canada, and New Zealand, but the politics was different because that was a response to US pressure to liberalize. So the direction of change was different. We see a similar move in Spain in 1986 as part of the accession process to the European Union. There was again a move to a similar sort of screening mechanism to those we see in that cluster. And that's an example of where, in the case of Spain, you can't really understand the investment law without reading the underlying regulations which establish the institutional structure for screening. But again, we can't claim comprehensiveness. We haven't read every regulation that sits under every investment law. It's just too vast. I really like the question about to what extent can national investment laws address climate change and environmental concerns. That could almost have been a plan. The short answer is we think the functional approach is really, really helpful here, because I think one of the problems is people recognize, obviously, climate change is a massive issue. They recognize it engages investment, and then it's like, so what to do? I mean, is this just about putting a preamble in with some general language to say that we think climate change is important? So the functional approach really helps you drill down. So insofar as investment laws deal with questions of investment protection, then the climate change engagement is really, we might say, sort of one of protecting policy space from constraint. So obviously stabilization clauses, which are found in a minority, but a significant minority of investment laws, are catastrophic in that respect, particularly when they're tied to internationalized mechanisms of dispute settlement. So that's a really good example of how the functional method helps us identify things that really shouldn't be in investment laws and can lead you to link back to the investment treaty discussion. So you can say, insofar as states are putting investment protections in their national laws, well, then that relates to some of the discussion that's going on in the OECD at the moment, which is, should fossil fuel investments even be entitled to those sorts of protections? But the functional approach is more helpful, especially when you get away from the protection functions, because it allows you to say, well, investment incentives, right? That's something that's still found in a majority of investment laws that exist now. So climate change is directly relevant to the question of the structure of investment incentives. So what sort of incentives are being granted to investments in what sectors, right? Like that's a climate change question. The question of investment screening, insofar as states establish discretionary screening mechanisms, then that's something that is potentially engaged in net benefit or national interest type screening. So we can break down helpfully, I think, how different functions relate to the climate change question. And that helps, I think, give much clearer set of policy options or choices to states rather than a general sense to say, oh, you should think about climate change generally in your law.
Well, thank you very much, Jonathan. Thank you very much, audience, for staying with us a bit later and for all of your insightful questions. I apologize to you who did not get to ask your questions. Please get Jonathan or Gustavo at their break, or if you have questions for the virtual speakers, you can email those questions to them, and I'm sure the organizers will give you their emails. So thank you very much. We also have to thank our technical support. That was excellent. It was perfect. Thank you. Oh, perfect.
So we don't have the time for the coffee though.
Yeah, you have to take your coffee to it.
That was good to have.
Thank you. Thank you.
Thank you.
Such a nice moderator.
Thank you.
Thank you, boss, for
Thank
giving
you.
us some
Thank
extra
you.
time.
Bye. Get some sleep, Waxia.
It turned out
Yeah,
well.
you too. You too. I'll write to you later.
Yeah,
For now,
let's
just like head to my bed. Yeah.
Yeah.
Bye.
Thank you.
See you later. Excuses for the camera, but and time is up. So thank you for everything.
Yeah,
See you
thanks.
later.
Thanks.
Goodbye.
Bye-bye. Bye.